The argument before the Supreme Court tomorrow is all about whether Donald Trump is ineligible for the 2024 ballot under Section 3 of the 14th Amendment. That amendment explicitly bars lawmakers from holding office if they have held office before and have engaged in insurrection or rebellion against the country. It was originally designed to prevent former Confederates from reclaiming their seats in Congress after the Civil War. And according to civil rights lawyer Sherrilyn Ifill, this clause quite straightforwardly applies to what we experienced on January 6th. She writes in her amicus brief, Section 3 was enacted for such a time as this and for such a figure as President Trump, designed to ensure that the ambitious rights the 14th Amendment guarantees can withstand the resistance that its framers knew was sure to recur, not just in the immediate post-war period, but far into the future. Sherrilyn Ifill holds the Vernon Jordan Chair in Civil Rights at Howard University, where she founded the 14th Amendment Center for Law and Democracy. She previously served as President Director Counsel for the NAACP Legal Defense Fund, and she joins me now. Sherrilyn, I enjoyed your brief a tremendous amount, and I think let's just start with the 14th Amendment. I think I want to raise this argument and get your response to it, which is, look, yes, they say insurrection in the text, and maybe what he did was insurrection-ish, but they were just really talking about the Civil War. Like, the plain meaning of it is basically, if you were a Confederate, if you flew the flag of treason against this country, you can't get to come back into Congress right now in this period where we're trying to stitch the country back together. What do you think of that?
Thanks so much, Chris. You know, it's such an interesting argument, which I've heard obviously repeatedly. And my response to it is one of the things that's so compelling about the 14th Amendment and its framers, and why I find it really the most important provision in the Constitution, is because it's doing these two things. It's providing all of these guarantees that suggest an expansive and full citizenship for Black people. It's promising equal protection and due process. It's establishing birthright citizenship. But it also takes a very hard look at the American character and the character of those who had been the opponents of the Union in the Civil War. And what they recognized when you read that legislative history is that they understood that there would be resistance, that these folks would not accept the full citizenship of Black people. And multiple legislators talked about the desire to protect the Union forevermore. They did not believe that it was just for the moment. I quoted in my brief Frederick Douglass, who talked about why Black people needed voting rights. He wanted there to be voting rights in the 14th Amendment. And he said it was the only way Black people could protect themselves against the traitorous spirit that he believed lived deeply within those who had been in the Confederacy. And he said, this traitorous spirit, he said, will be passed from sire to son. It will not end in a year. It will not end in an age. They understood that they were creating something that was designed to protect against what they saw to be a deeply embedded spirit at that time in the American South, but certainly in those who resisted the full citizenship of Black people. So no, this was not just meant as a stopgap for 1868 or for 1869. That's why it's in the Constitution and it's not a statute. It is designed to protect our republic forevermore.
The Washington Post did a sort of handy kind of breakdown of some of the points that are going to be argued in contention tomorrow. Is the president an officer? Again, I think that's a little too cute by half. I'm just going to sort of put that to the side. If they want to weasel out of this, I guess they can do it, but I don't think it's very strong. The president also takes a different oath, which again feels a little too cute by half. Did he engage in insurrection, which I think is a interesting, legitimate question, right? It's a meaty one, although you've got the factual record of the state trial. So, like, you can't really second guess what they're doing. You could second guess it from a process perspective. But then this question that Lawrence Lessig just raised in his objection, he basically says Congress is required to enforce it. That basically other provisions of the section of the 14th Amendment were understood at the time as not self-executing. They required further congressional action. Congress took such action. In fact, one of those pieces of legislation, famously known as the Enforcement Acts, and that absent congressional action here, there's just not enough guidance or specificity about the process. What do you say?
Well, what action did Congress take to establish birthright citizenship, which was created to overturn the Dred Scott decision and to ensure that Black people, both formerly enslaved and free, would be citizens of the country? If you read Section 3 of the 14th Amendment, yeah, no, please, I'm sorry to have interrupted, but yes, if you read the Section 3 as overturning, there's a lot of overturning happening in the 14th Amendment, right? Yep. So we have birthright citizenship, which overturns Dred Scott. We also have in Section 2 the requirement that we're counting every person, as a whole person. That overturned the 3/5 compromise, right? And Section 3 is essentially an amendment to the qualifications for holding office. And in the case of the president, it's an amendment. It serves as an amendment to Article 2, Section 1. We don't need a congressional statute to enforce the fact that you have to be 35 years old to serve as president. We don't need a congressional statute to enforce that you have to be a natural born citizen, that is born in the United States, to be president. We don't need a congressional statute to establish that you have to have resided in the United States for 14 years in order to be president. And all Section 3 does is add another requirement, another eligibility requirement, not only for the president, but for all who have formally taken an oath. And that requirement is loyalty. So it's not tremendously complicated. The question you asked about whether he participated in insurrection, I think that becomes the only complicated question, uncomplicated by the fact that a legitimate trier of fact reviewed all the evidence in a tribunal in which Mr. Trump had the opportunity to represent himself and to be represented, and he was, and presented evidence. And that tribunal found that he participated in insurrection. The Supreme Court, much as it might want to be, on occasion, and we heard this from Justice Alito last term, may want to be a fact finder. They are not fact finders. It is a reviewing court. It is an appellate court. And the fact finding in this case as to whether or not Mr. Trump engaged in insurrection has already been done. And so the question is whether or not the Supreme Court will hold fast to the role that they appropriately should be in, which is as an appellate court. They certainly hold the power to say what the law is, but they don't hold the power to overdo the fact finding of the Colorado trial court that was upheld by the Colorado Supreme Court.
Yeah, that is a really important point for people to sort of sit with about, there was a trial, it was a 5-day trial, there was evidence, there was process. This is the factual determination of that court. And furthermore, it's a court that is a state court whose, fact-finding is basically fully outside the portfolio and ambit of the Supreme Court, at least it should be. I think that won't stop them at oral arguments, but we'll see where they end up. Sherrilyn Ifill, such a pleasure as always. Thank you.
Thank you, Chris.
Well, that was fun. I got to pretend like I was an appellate judge for an hour and just pepper people with questions. It wraps it up for this special hour of coverage. Tomorrow, the whole primetime MSNBC gang will be back here to break down what happens in the Supreme Court after those oral arguments. That's from 8 p.m. to 10 p.m. tomorrow. The oral arguments themselves are at 10 a.m. I'll be listening to them, I hope.
Relinquish what remains of the Allspark.
So who's the insect? You? What? Who's the insect?
Protect you. They will defeat it on our world, and we will defeat them here.
This was just a diversion. Security teams bring up. Rabbit, she's already inside. Deeds. Give me an update on that reserve. What's readiness? What was his name? What was it?
Evac, sir.
Right, evac.
She's right in front.
We are facing a heavy, sustained attack. They appear to be after the Allspark. General! General! Immediately, General! Hold on. National security advisory. Stand down! Pushing it out! There is a separation. The amateurs are suicide mission.